Welcome to the New Sentinel. Today we examine Executive Order 14160, issued the 20th of January 2025.
Its title is Protecting the Meaning and Value of American Citizenship, and its focus is birthright citizenship.
Specifically, it attempts to limit citizenship for children of parents unlawfully present or only temporarily present.
This report treats the order as a strategic policy move, a legal trigger, and a political signal.
We will use two analytic tools, MOST analysis and SWOT analysis.
MOST means mission, objectives, strategy, and tactics. SWOT means strengths, weaknesses, opportunities, and threats.
Let us start with the central intelligence judgment, based only on the stated policy attempt.
The order seeks to redefine practical access to automatic citizenship at birth for certain children born in America.
Its immediate effect is not just administrative. It pressures the legal system to answer a foundational question.
That question is whether executive action can narrow a citizenship rule long treated as broad.
Because the order targets parental status, it shifts attention from the child's birthplace to the parent's immigration category.
That shift is strategically important. It changes the debate from identity and inclusion to eligibility and sovereignty.
Now the MOST analysis. First, mission. The stated mission is protecting the meaning and value of citizenship.
Operationally, the mission appears to be limiting automatic citizenship when parents lack permanent legal status.
That mission carries a clear message. Citizenship should be treated as a guarded national asset.
It also signals that immigration status should matter at the earliest point of civic recognition.
Second, objectives. The first objective is likely legal clarification through confrontation with existing understandings.
A second objective is administrative direction, telling agencies how to treat covered birth circumstances.
A third objective is political framing, presenting birthright citizenship as a policy vulnerability.
A fourth objective is deterrence, by reducing incentives tied to a child's automatic citizenship.
Those objectives are connected, but they are not identical. Legal, administrative, political, and deterrent effects differ.
That matters because an order can succeed politically while struggling legally, or reshape debate without lasting implementation.
Third, strategy. The strategy appears to be executive assertion first, followed by institutional testing.
Instead of waiting for legislation, the order pushes the issue into enforcement channels and courts.
That creates urgency. Agencies, families, states, and courts must respond to a changed federal posture.
Strategically, it also forces opponents to defend the existing interpretation under pressure and time constraints.
Fourth, tactics. The core tactic is defining categories of parents, unlawfully present and temporarily present.
Another tactic is using birth documentation and recognition processes as practical pressure points.
A further tactic is symbolic language. The title frames the order as protection, not restriction.
That wording matters. It asks supporters to see exclusion as preservation of citizenship's value.
The MOST conclusion is straightforward. The order is designed for impact beyond routine administration.
It is a deliberate attempt to recast citizenship as conditional on parental legal status.
Now to SWOT. We begin with strengths, from the order's strategic perspective.
The first strength is message clarity. It gives supporters a simple claim: citizenship should have boundaries.
The second strength is executive speed. An executive order can move faster than a legislative campaign.
The third strength is agenda control. It makes birthright citizenship a frontline national issue immediately.
The fourth strength is category focus. It does not challenge every birth, only specified parental situations.
That narrower framing may help supporters present the measure as targeted rather than sweeping.
The fifth strength is deterrence messaging. Whether effective or not, the policy communicates reduced future benefits.
Now, weaknesses. The largest weakness is legal vulnerability, because citizenship rules sit at the highest level of law.
The order may face challenges over whether executive authority can accomplish this kind of limitation.
A second weakness is implementation complexity. Birth occurs locally, while citizenship recognition involves layered government systems.
A third weakness is family uncertainty. Newborns could become the center of unresolved legal status disputes.
A fourth weakness is evidentiary burden. Officials may need reliable parental status information at birth.
That creates risk of inconsistent application, delays, mistakes, and unequal treatment across jurisdictions.
A fifth weakness is reputational cost. Critics can frame the order as punitive toward children.
Now, opportunities. The first opportunity is judicial review that could clarify the limits of executive power.
The second opportunity is legislative debate. The order may push lawmakers to define their positions.
The third opportunity is administrative modernization. If agencies review documentation standards and citizenship recognition procedures.
The fourth opportunity is political coalition building among voters who favor stricter immigration-linked citizenship rules.
The fifth opportunity is negotiation. A controversial order can become leverage in wider immigration policy talks.
Now threats. The first threat is rapid injunction or legal defeat, which could blunt enforcement.
The second threat is a fragmented national response, with conflicting practices while litigation unfolds.
The third threat is social polarization, especially because the issue involves children, identity, and belonging.
The fourth threat is administrative overreach, where agencies act beyond clear guidance and create avoidable harm.
The fifth threat is international perception, if the policy is read as reducing openness or stability.
The SWOT balance shows a high-impact but high-risk initiative.
Its strengths are speed, clarity, and agenda setting. Its weaknesses are legality, execution, and human consequences.
For an intelligence report, we should separate intent, capability, and likely effect.
Intent appears clear. Narrow access to birthright citizenship for children in specified parental status situations.
Capability is more uncertain. Executive power may direct agencies, but courts may constrain final outcomes.
Likely effect is immediate disruption in expectations, even before any final legal resolution.
The first affected group is families whose children fall within the order's targeted categories.
They face uncertainty over documents, status recognition, and the practical meaning of birth in the United States.
The second affected group is federal and local administrators who must interpret and apply new instructions.
They need clear criteria, reliable data, and procedures that avoid arbitrary decisions.
The third affected group is courts, because the order almost certainly invites legal challenge.
The fourth affected group is political actors, who will use the order to mobilize supporters and opponents.
From a risk perspective, the most important variable is speed of legal review.
A quick ruling could freeze or clarify implementation. A prolonged fight could magnify uncertainty.
Another variable is agency guidance. Broad or vague guidance would increase confusion and litigation risk.
Narrow, precise guidance might reduce chaos, but it would not remove the central legal dispute.
The order's language also matters. Protecting meaning and value is persuasive language, not merely technical language.
It frames citizenship as something that can be diluted unless the government intervenes.
Opponents will likely frame the same move differently, as exclusion from citizenship at birth.
That rhetorical divide will shape public understanding as much as the technical legal arguments.
In intelligence terms, this is a values conflict embedded in administrative machinery.
It is not only about forms and eligibility. It is about national identity and membership.
The order also creates a signaling effect abroad and at the border.
Its message is that temporary or unlawful parental presence should not secure automatic citizenship for a child.
Whether that changes behavior is uncertain. Deterrence depends on awareness, credibility, and enforcement durability.
If people believe courts will block the order, deterrent value may weaken quickly.
If people believe the order will survive, it could alter migration calculations for some families.
But we should avoid overstating that effect. The available material does not prove behavioral impact.
Now, let us assess scenarios. Scenario 1. The order is blocked early.
In that case, Its main impact becomes political messaging and a record for future legal arguments.
Scenario 2. Parts of it proceed while litigation continues.
That creates the highest administrative burden because officials operate under uncertainty and families face uneven treatment.
Scenario 3. The order is upheld in meaningful form.
That would mark a major shift in how citizenship at birth is applied to covered children.
Scenario 4. The order prompts legislation rather than standing alone.
Then its role becomes catalytic, pushing Congress or political campaigns toward a broader settlement.
For stakeholders, the recommended posture is disciplined monitoring rather than assumption.
Track court actions, agency instructions, documentation rules, and actual treatment of birth records.
Also track political messaging, because public pressure can affect enforcement intensity and legislative priorities.
For businesses and institutions, the practical issue is workforce and family uncertainty among affected communities.
Employers, schools, hospitals, and service providers may need clear intake policies and referral pathways.
For advocates, the priority is identifying cases where newborn recognition is delayed or denied.
For policymakers, the priority is clarity. Ambiguous rules create avoidable legal and human costs.
For media, the priority is precision. The order targets specific parental categories, not every birth.
But precision also requires acknowledging uncertainty. The final legal effect may differ from the executive aim.
That is the key distinction. Policy intent is visible, but enforceable outcome remains contested.
Let us close with the intelligence bottom line.
Executive Order 14160 is best understood as a high-stakes test of citizenship boundaries.
Its mission is to protect citizenship's meaning, as framed by the order itself.
Its operational objective is limiting birthright citizenship for children of unlawfully present or temporary status parents.
Its strategy is executive action first, followed by legal and political confrontation.
Its tactics rely on parental status categories, agency compliance, and symbolic framing.
Its strengths are clarity, speed, and agenda setting. Its weaknesses are legal exposure and execution complexity.
Its opportunities are clarification, debate, and coalition building. Its threats are litigation, fragmentation, and polarization.
The most likely near-term effect is uncertainty, not final settlement.
The long-term effect depends on courts, agencies, lawmakers, and public acceptance.
For the new Sentinel, the takeaway is simple. This is not a narrow paperwork dispute.
It is a strategic fight over who is recognized as American at the moment of birth.
As always, stay informed, question assumptions, and keep the analysis grounded in what is known.
Subscribe, comment, and follow the new Sentinel for deeper dives across security, policy, and culture.